The domain name dispute I want to talk about today doesn't seem out of the ordinary at first glance, but it holds an important lesson for trademark owners and domain name registrants alike. In a nutshell, the lesson is that, at least under the right circumstances, a trademark owner may be able to win a proceeding under the UDRP, the Uniform Domain Name Dispute Resolution Policy, even if its trademark rights arose after the disputed domain name was registered, if the trademark owner previously registered and used an almost identical domain name. So I know that may sound a little confusing, so let me start by just laying out the facts. The case I'm talking about was filed by the American Farm Bureau Federation against a company called Portfolio 16 Management Limited. The complaint was filed at WIPO, the World Intellectual Property Organization, in March 2023, and it was decided in May 2023. According to the UDRP decision, the American Farm Bureau, the complainant, is a national advocate for farmers, ranchers, and rural communities in the United States, and it owns registrations for the trademarks Texas Farm Bureau and Texas Farm Bureau Insurance. The complainant licenses these trademarks to the Texas Farm Bureau, which owns or controls a series of insurance companies that provide insurance services to its members. The decision also says that the American Farm Bureau owns and operates a website at the domain name txfb-ins.com, which apparently is used for the benefit of the Texas Farm Bureau. The disputed domain name in this case is txfbins.com, identical to the complainant's domain name except for the absence of a hyphen. And the decision says that the domain name was used in connection with the PPC or pay-per-click website with advertising links labeled Texas Farm Bureau and Farm Bureau Insurance. The decision also says that MX or mail exchange records were established for the domain name and that the domain name was listed for sale on a third party's platform. Now, what I find most fascinating about this case involves the complainant's trademark rights and its own domain name. To understand what I'm talking about requires an understanding of the relevant dates, so here goes. According to the decision, the disputed domain name, txfbins.com, was registered in 2000, but the complainant did not obtain its trademark registrations for Texas Farm Bureau and Texas Farm Bureau Insurance until 2012. The decision says that the complainant claimed common law trademark rights since 1952, but the decision contains no discussion about whether these rights were properly established, and the panelist discussion and findings never refer to common law trademark rights. So normally, this sequence of events, where a disputed domain name was created before trademark rights were established, is fatal to a UDRP complaint. And that's because the UDRP specifically requires a complainant to prove that the disputed domain name has been registered and is being used in bad faith. In other words, bad faith must be established at 2 points in time: when the domain name was registered and when the complaint was filed. So as the WIPO overview simply states, where a respondent registers a domain name before the complainant's trademark rights accrue, panels will not normally find bad faith on the part of the respondent. But that was not the end of the story in the Texas Farm Bureau case. And that's in part because the complainant had registered and started using its own domain name, txfb-ins.com, without the hyphen that appears in the disputed domain name, in 1998. And that's before the disputed domain name was registered in 2000. Apparently, the panelist found that important in evaluating the bad faith element of the UDRP. Specifically, the decision says the disputed domain name was registered before the complainant registered its trademarks referred to above. However, the complainant has also provided evidence of long-standing use and reputation prior to the respondent registering the disputed domain name. In particular, the complainant registered and commenced use of its domain name, txfb-ins.com, which is similar to the disputed domain name, 2 years prior to the respondent registering the disputed domain name. The respondent's conduct demonstrates the respondent's knowledge of the complainant and the complainant's trademark. By registering the disputed domain name after the complainant started to use and advertise its similar domain name, and then by using the disputed domain name to generate PPC traffic that referred to the complainant, demonstrates that the respondent specifically knew of and targeted the complainant. Now, in my opinion, that's an incredibly important and helpful finding for UDRP complainants because it allows a trademark owner to establish bad faith based on its prior use of a domain name that's similar to the disputed domain name, even if it can't establish that it had earlier trademark rights. And this decision, if followed by other panelists, could greatly expand the ability of trademark owners to prevail in UDRP proceedings. Because as I know from personal experience with my own clients, sometimes a person or company will register and start using a domain name before it acquires any trademark rights, simply because it's a lot quicker, easier, and less expensive to register a domain name than it is to register a trademark. So at least under the circumstances of the Texas Farm Bureau case, the date on which a trademark owner obtained and started using its domain name could help it establish the UDRP's bad faith element. Now, before I wrap up, I also want to mention something else that I found interesting in this case, and that's the use of the letters FB in the disputed domain name, even though the complainant only owned trademark registrations that included the words Farm Bureau. Now, there are more than 100 previous UDRP decisions just at WIPO containing the letters FB, dozens of which were filed by Facebook and its parent company Meta Platforms because they own trademark registrations for FB, which Meta has said commonly refers to Facebook. Of course, Facebook has nothing to do with the Farm Bureau case I'm talking about now, but I find it interesting, at least just as a side note, that two letters can serve as an abbreviation for two different companies or trademark, which at least means that it's sometimes impossible to look at a domain name by itself and understand who the intended target really is. And that's something the panelist in this case alluded to, although he did not specifically note the Facebook connection. After stating that prior panels have found an abbreviation in a domain name can be confusingly similar to a trademark from which the abbreviation derives, the panelists still seem to be looking for something more, which he found by looking at how the disputed domain name was actually being used. And on that issue, here's what he wrote. The panel reviewed the website of the disputed domain name and can draw the conclusion that the content of the website confirms confusing similarity, since it appears prima facie that the respondent sought to target the complainant and the complainant's trademark through the disputed domain name. Further, considering the content on the website of the disputed domain name, the panel concludes that the letters TXFB in the disputed domain name are references to the complainant and the complainant's trademark. So this was obviously an interesting case for multiple reasons, but don't be misled. Nothing in the Texas Farm Bureau case relieves a UDRP complainant from having to establish trademark rights. The decision makes clear that American Farm Bureau had two trademark registrations that were obtained almost 11 years before the complaint was filed. Trademark rights will always be a necessary element of every UDRP complaint. It's just that, as I said before, under some circumstances, a trademark owner may be able to rely on an earlier date of its own domain name registration to establish the bad faith element. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.